Good evening from New York. President Obama has said that Americans who tortured would not likely be prosecuted unless, that is, they strayed from the legal guidelines established by the Bush Office of Legal Counsel inside the Justice Department. In our fifth story tonight, a new problem for both Mr. Obama and the former Bush administration. News that the torturers did not stay within George Bush's own guidelines. Thus, Mr. Bush's Justice Department reacted by rewriting the guidelines. On August 1st, 2002, OLC lawyer John Yoo wrote in a memo signed by Assistant Attorney General Jay Bybee a new legal rationale for and prescription for the act of waterboarding a detainee. Quote, once the cloth is saturated and completely covers the mouth and nose, airflow is slightly restricted for 20 to 40 seconds due to the presence of the cloth. This causes an increase in carbon dioxide level in the individual's blood. This increase in the carbon dioxide level stimulates increased effort to breathe. This effort plus the cloth produces the perception of suffocation and incipient panic, i.e. the perception of drowning. The perception of drowning. To continue, quote, the individual does not breathe any water into his lungs. No water in the lungs, perception of drowning, the legal parameters set down by the Bush administration for waterboarding. On July 30th, 2004, Assistant Attorney General Jack Goldsmith rescinded the Bybee memo, revoking the legal rationales for waterboarding and other torture methods. Goldsmith then resigned, later saying he had hoped he had sealed the end of OLC's attempts to rationalize torture. He had not. His successor, Stephen Bradbury, issued a series of new memos, noteworthy at first for reauthorizing torture, but examination of these newly released memos dating from 2005 has now shed a grim light on exactly what happened under the previous authorization. America tortured even by the Bush definition. In his memos addressing the CIA, Bradbury refers to secret information about the CIA's actual waterboarding. Quote, we understand that water may enter and may accumulate in the detainee's mouth and nasal cavity, preventing him from breathing. In addition, you, the CIA you, have indicated that the detainee, as a countermeasure, may swallow water, possibly in significant quantities. Inhaled water, preventing detainees from breathing. By Mr. Bush's own definition, beyond the legal rules for torture. And despite the Bybee memo's original claim that waterboarding does no long-term harm, the Bradbury memo reveals just how much harm the CIA prepared itself for. Quote, a detainee could suffer spasms of the larynx that would prevent him from breathing even when the application of water is stopped. Obviously, not breathing will kill you. So how is that not long-term harm and therefore torture in the Bush administration? Quote, a qualified physician would immediately intervene to address the problem, and if necessary, the intervening physician would perform a tracheotomy. It was not torture because they had doctors standing by, ready to cut their throats open and shove a tube into their lungs to keep them alive. Let's turn now to Professor Jonathan Turley, constitutional law scholar at George Washington University. John, thanks for your time tonight.
Hi, Keith.
Can you explain the legal ramification of the news that the waterboarding did, in fact, go beyond the first Bush rationale as soon as that first drop of water went down somebody's throat?
Well, what you're seeing is really a system of cascading failure. That is, they're trying to presume facts that then collapse on them. They presume more facts until ultimately they write their memos based on the assumption that waterboarding causes no pain, which is, of course, laughable since it's been treated as an act of torture since the Spanish Inquisition. And having a doctor there is a rather novel way of viewing torture as a defense. We would not have said that the Japanese we prosecuted for waterboarding U.S. and English soldiers in World War II were not torturers because there was a Japanese doctor at these prison camps. When the Reagan administration prosecuted a sheriff in Texas for waterboarding criminal defendants, there wasn't a suggestion that only they had a doctor helping them that would have been anything less than abuse and torture. And so you're really seeing them struggling, trying to find any way possible to say that they're not engaging in a war crime because they expect that they will be charged with a war crime.
The Defense Department was warned right off the bat that the psychological impact of waterboarding one of our own as part of training, as part of that SEER program, for instance, was different from real waterboarding of an enemy. Does the psychological difference alone make it torture, and what does it mean that the Department of Defense knew about this?
Well, first of all, the Convention Against Torture refers to physical or mental suffering. So this idea that it has to cause prolonged physical injury is simply outside of the cases that really govern this area. So there's no question it could still be that. The use of the SEALs program has always been a canard. I mean, it's never been particularly persuasive. It's like saying that we put people in a jail knowing that they'll get out the next day, and that type of segregation didn't affect them. Well, it didn't affect them because they knew they'd get out the next day. Mm-hmm. And when you're being tortured as a sort of faux torture in training, it's not that I'm suggesting it is in any way pleasant, but there's a big difference when you know they're not going to let you die. But it doesn't really matter. All of these Bush lawyers who are trying so mightily to find some way that they can torture people have the weight of all the cases and, frankly, the world against them. Nobody who investigates this is going to conclude that waterboarding is not torture. It is not going to be even on the table. It is a well-established fact, and that's the way it's going to be. That's why all these people who are saying waterboarding, that this isn't torture, are also opposing investigation. Why? Why wouldn't you want a special prosecutor who can vindicate President Bush and Vice President Cheney? If you're so confident, let's get a neutral prosecutor to look at this. And it's because they're not confident at all, or at least they may be confident in the wrong result from their interest.
And now another president's lawyer is examining this, even by his own narrow definition of who should be investigated in this. Does President Obama now have a whole new legal, a whole new moral obligation to address?
He really does. I mean, we now know that the Bush administration did what, frankly, a lot of criminal enterprises do. They bring in people to expose them to what they know to be an illegal program or illegal act. It's a lesson that, frankly, I know some of my past clients used in their organizations. And so they even brought in Democratic senators to get them to buy into the program. But there's this notion that if you have so many people who knew about it, it's less of a crime. Of course, that's ridiculous. It's a worse crime. That if you're a rogue operator and nobody knew that you tortured, it'd be treated as a simple crime. A war crime is the concern there is that it was coordinated and premeditated, and many people participated in it, and that's exactly what we have here.
Jonathan Turley, professor of constitutional law, as always, great thanks for your time tonight, sir.
Thanks, Keith.